You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diament, founder of Diament Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, episode 134. What is patent insurance and do I need it? My name is Adam Diament, a registered patent attorney and founder and owner of Diament Patent Law in Los Angeles, California. Let's dive into the subject. I was recently asked by a client if I could give them some information about patent insurance, and I realized that I never did an episode about patent insurance. So I'm going to go through a few of the basics on what it is and what it isn't and what it's good for and what maybe is not good for. First thing to know is that there are essentially two types of patent insurance. There's offensive insurance and defensive insurance. If you think about it, if you're selling a patented product, there are two types of things that can happen. You might want to sue someone for infringing your product, but you also might be on the receiving end of a lawsuit. If you want to sue someone, that would be offensive because you're going on the attack, and if you're being sued, then you're on the defensive. Let's talk about defensive patent insurance first. You might want to get this whether or not you have a patent on your product. And this makes sense because whether you have a patent on your product or not, you can still be sued for infringing someone else's patent. Defensive patent insurance covers a few things. It covers the cost of defending your company in a patent lawsuit by paying a portion of the legal fees for damages to your company. It's especially useful if you're in a business where there's a lot of patents around that technology. For offensive patent insurance, you might see this called abatement and enforcement coverage or patent enforcement coverage. It's only necessary if you actually have a patent because you can't sue anyone for patent infringement if you don't have a patent. This can cover the cost of taking a party to court for patent infringement and pays a portion of the legal costs. Now, why would you want patent insurance? And when is it worth it? Well, patent infringement damages can be huge, tens of millions of dollars or more. In a patent case of Polaroid v. Kodak, there was a $900 million in damages award. In Honeywell v. Litton, there was $1.2 billion awarded in damages. And I read one study that said a patent lawsuit costs about $3 million for inventions that are worth between $1 and $25 million. But that doesn't include the damages, which are about $9 million for inventions in that range of value. Now, how much does it cost? It could really depend on what kind of plan you have. But in an offensive policy, that may pay about 75% of the legal cost. And like any insurance plan, there's a deductible, so you'll have to put up the initial amount yourself. The insurance company wants to have a deductible because if they're just going to be paying for everything up front, then you, the patent owner, just might go around suing everybody, even if you don't have a strong case. So by you having to pay a deductible, it protects the insurance company a little bit so you don't go lawsuit crazy. For a defensive policy, then the insurance company usually covers a percent. Let's say you have a policy for $1 million and the policy charges you 3% for your coverage. Then you would pay about $30,000 for the premium. Typically, premiums range from about 1% to 5% of the insurance amount. Now, you want to be careful in knowing what you're getting when you get patent insurance because maybe the insurance just covers potential damages if you're found liable for patent infringement, but may not cover the actual legal costs. So read your policy carefully about deductibles and copays that must be paid by the company. But depending on the value of your products that you're making, rates usually run anywhere from a few $1,000s to about $25,000 annually. It's going to be dependent on what kind of industry you're in, how many patents you have, the coverage amount, what deductible you have, and other factors. Also, remember to read your policy to see if you're getting specific patent insurance or whether your insurance covers other intellectual property such as trademarks and copyrights. So, should you get patent insurance? That's really up to each individual or company. If you lose a lawsuit, is the amount high enough that your company is totally finished? Or is it something where you can handle the potential loss? Remember, there are millions of issued patents in the US, plus patents in foreign countries. You can think of these as paper landmines, and whether you want to get patent insurance to protect you from these potential landmines is up to you, but you should be aware of them, and if you're a company that never contemplated patent insurance, it's probably something you should bring up to your insurance agent, because there's a good chance you have insurance for other parts of your business, but patent and IP insurance generally isn't included in that basic policy. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamantpatentlaw.com or call me at 424-281-0162. I'm Adam Diament, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. For more information and help with your own intellectual property needs, contact Adam Diament directly by going to diamantpatentlaw.com. That's DIAMENT patentlaw.com. Or click the show links to connect by phone, text, or social media. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.